So make sure I understand your answer to Justice Thomas. A threat of a subpoena is not enough. It has to be an actual subpoena.
That's correct, Mr. Chief Justice. I wonder, sorry, Justice.
I was just going to ask you on this, was this really non-self-executing or self-executing? You say in your brief, we'll accept the lower court's characterization of it as non-self-executing.
Correct.
It's my understanding that the New Jersey court treated it that way, too, because the New Jersey, I don't know that there was an express holding by the New Jersey court, and maybe the Attorney General can address that. What is your view of the best reading of this statute?
We accept that New Jersey subpoenas are not self-executing. The face of the subpoena suggests that it is self-executing, but we accept that regardless of what the subpoena says on its face, the courts have treated it as non-self-executing.
And the face of the subpoena, however, the language that it used does go to the credible threat theory, which seems like that was part of your answer to Justice Thomas in distinguishing the letter from the subpoena.
That's correct.
What problems do you see with the chill theory?
There are two main problems. The first is that this court has a series of cases saying a subjective chill is not enough for Article III standing. Laird versus Tatum, Clapper, and Whole Woman's Health against Jackson. So you'd have to draw a distinction between an objectively reasonable chill and a subjective chill. The second is that the chill is highly relevant to the merits and to irreparable injury, and there's a risk that courts might conflate the Article III requirements with the merits requirements. You'd have to draw fine distinctions about, for instance, whether a particular degree of chill may be sufficient for Article III, but not necessarily sufficient on the merits to prevail on the First Amendment claim. If the court is uncomfortable, however, with the breadth of our credible threat theory, then the backup we would urge the court to adopt is to say credible threat plus a chill is enough, leave for another day whether the credible threat alone would be sufficient.